Welcome to the Oprah Show, everybody. With the closing of our 25th and final season, my producers wanted to have a show dedicated to influential court stories. That brings us to the beginning of our show with a very important guest, Mr. Charles Katz.
It is great to be here, back from the dead, to be a part of your farewell season.
Well, let's jump right into it, shall we? The petitioner, Charles Katz, was charged with conducting illegal gambling operations across state lines in violation of federal law. In order to collect evidence against Katz, federal agents placed a warrantless wiretap on the public phone booth that he used to conduct these operations. The agents listened only to Katz's conversations, and only to the parts of his conversations dealing with illegal gambling transactions. In the case of Olmstead v. United States, 1928, the Supreme Court held that the warrantless wiretapping of phone lines did not constitute an unreasonable search under the Fourth Amendment. According to the court, physical intrusion into a given area, and not mere voice amplification, the normal result of a wiretap, is required for inaction to constitute a Fourth Amendment search. The Supreme Court refined the Olmstead trespass doctrine by holding that an unreasonable search occurs only if a constitutionally protected area has been intruded upon. At his trial, Katz sought to exclude any evidence connected with these wiretaps, arguing that the warrantless wiretapping of a public phone booth constitutes an unreasonable search of a constitutionally protected area in violation of the Fourth Amendment. The federal agents countered by saying that a public phone booth was not a constitutionally protected area, therefore, they could place a wiretap on it without a warrant.
Oprah, I first want the American people to know that I argued that the government had violated my Fourth Amendment rights, the right of the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures. I said that the illegally gathered evidence against me should have been excluded from this trial.
Well, Mr. Katz, to our government student viewers, what was the constitutional question in this case?
Oprah, as you briefly covered, the question was, is the Fourth Amendment protection from unreasonable search and seizure restricted to tangible property, or does it extend to intangible areas, or over the telephone?
Well, what were your arguments in your defense?
Mrs. Winfrey, the Fourth Amendment requires that a warrant be issued stating the probable cause for a search and names of the persons or things to be seized. In bugging the phone booth, the FBI used none of the guidelines. Moreover, a phone booth, although public, becomes private when a person uses it for confidential conversations. It becomes a constitutionally protected area just like a person's home or office. Finally, the Olmstead v. USA decision should have been overturned, as should my conviction. I mean, Oprah, how would you feel if someone listened to your conversations on the phone?
Mr. Katz, don't compare this to me. You were charged with conducting illegal gambling operations across state lines in violation of federal law. But I am not here to judge. Some of you might be wondering how the United States argued against Katz. My following statement was taken from one of the FBI agents who tapped the phone booth listening to Katz. The Fourth Amendment protects against unreasonable searches and seizures conducted without a warrant. In this case, no tangible property was searched or seized, so the Fourth Amendment does not apply. A telephone booth is a public place and Katz made no effort to make it private. A phone booth, in short, is not a constitutionally protected area. Lastly, the Olmstead decision provided a precedent which the FBI agents followed and which the court should uphold. There was no physical entry of the booth itself, according to Olmstead, meant that the evidence was obtained legally. I am sure our viewers are on the edge of their seats waiting to hear the decision of the court. Wait no longer. Mr. Katz, what was the decision of the court?
In my case, Katz v. United States, the Supreme Court overturned the decision in Olmstead v. United States and my conviction along with it. Justice Potter Stewart argued that the Fourth Amendment protects people, not places. It protects an individual's right even in a place accessible to the public, such as a telephone booth on a street corner. Justice Stewart wrote, "The government's activities in electronically listening to and recording my words violated the privacy upon which he justifiably relied while using the telephone booth and thus constituted a search and seizure within the meaning of the Fourth Amendment."
Well, I am glad, Mr. Katz, that you won the case. The Katz case expanded the scope of Fourth Amendment rights to include protection against certain kinds of electronic invasions of an individual's privacy. Since the Katz decision, the Fourth Amendment has been a means to protect individual privacy in places open to the public. Versus United States, law enforcement personnel must apply for a court's permission to use electronic surveillance at the state and local level, and their application must be handled in the same way as applications for a search warrant. Thank you for discussing this with us.
No problem. Thank you for having me.